Hello and welcome back to another update in the Vallow Daybell case. Today I'm going to read for you a recent filing by John Pryor. It's his memorandum in support of a change of venue. Now this hearing is going to be held on January 6th, allegedly. We're going to have to wait and see, but I'm pretty sure we're going to hear it then. And if it is streamed live, I will bring it to you live on January 6th. So mark that date. If the date changes, I'll let you know. Now this is kind of a long document. I like to read through these things, so let's get right into it. I'm going to read it kind of quickly, and then we can talk about it later. Here we go. Comes now the above-named defendant, Chad Guy Daybell, by and through his attorney of record, John Pryor, and hereby submits this memorandum in support of his motion to change venue. The grounds of the motion. The venue should be changed because a fair and impartial trial cannot be had in Fremont, Madison, or Bonneville counties. The right to a fair trial and an impartial jury is guaranteed by the 6th and 14th Amendments to the United States Constitution and Article 1, Section 7 of the Idaho Constitution. A court should grant a change of venue whenever the totality of existing circumstances demonstrates that the juror exposure to pretrial publicity will likely result in an unfair trial. However, a defendant's inability to make a detailed conclusive showing of the prejudice is not a proper ground for refusing to change venue, as prejudice seldom can be established or disproved with certainty. Rather, it is sufficient for the accused to show there is a reasonable likelihood prejudicial news coverage will prevent a fair trial. When reviewing the nature and content of pretrial publicity, this court should consider the accuracy of the pretrial publicity, the extent to which articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of articles, and whether the potential jurors were so incessantly exposed to such articles that they had suddenly become conditioned to accept a particular version of the facts at trial. In the present case, the comments, articles, survey, news media that I have previously submitted to the prosecution and the court as exhibits in this case illustrate that the small rural communities of the 7th Judicial District have been exposed to inflammatory and inadmissible evidence and an overwhelming amount of media coverage. The small population of residents within the 7th Judicial District makes it impossible to obtain a fair impartial jury within the 7th District because the local media, religious organizations, and government agencies allowing depiction of pictures, ribbons on state property contribute to unfair bias. To support this assertion regarding inadmissible and inflammatory evidence, there has been an overwhelming amount of local reporting related to Ms. Vallow's activities in Arizona prior to any relationship with Mr. Daybell. Articles and audio recordings of Ms. Vallow insinuating her right to cause harm to her third husband, a video recording of a material witness expressing her views on the case. Additionally, inflammatory and untruthful information that has been reported by local media insinuates that Mr. Daybell had some role in his wife Tammy Daybell's death. The prosecutor continues to allow this inaccurate information to continue by not providing the autopsy results performed on Tammy Daybell, despite it having been performed a significant time ago. The advancement of this narrative in a small population area only continues to taint the potential jury pool. That counsel for the defendant Chad Daybell has not granted any public interviews, has not given any statement to the press for publication. Rather, counsel for Mr. Daybell has purposely and intentionally kept quiet even when the media continues to report facts that defense takes issue with. The prosecution, through the county, has employed a public relations firm to handle all media requests and comments directed to them. Information to defense counsel suggests they are trying to advance their own narrative of the case. The special prosecution, Fremont and Madison County officials allowed ribbons to be placed and pictures posted up on the courthouse and government property until I brought it up to the magistrate court's attention, at which time they were suddenly removed and the public relations firm for the county was retained. The communities in Fremont, Madison, and Bonneville counties are predominantly LDS communities. Although religion in no way disqualifies anyone to serve in the case, at the direction of the stake president in Henry's Fork, Mr. Daybell's sister, actually Mr. Daybell's sister-in-law, sent a mass email to all the ladies within the Henry's Fork stake, only causing greater concern that any potential jury pool would be tainted. There was a request of the Henry stake president to Mr. Daybell's sister-in-law to communicate to all of the ladies within that stake regarding the facts as she sees them. It should be noted that in the discovery provided to me at this point, it does not show that Mr. Daybell's sister had any personal information or involvement in the case. Rather, it has been suggested to the defense counsel through investigation that she is related through marriage to law enforcement who may be and may have investigated this case. That causes defense counsel great concern, as it would seem on the face of her assertions in her email to all the ladies of the Henry's Fork stake that she has personal knowledge of the facts. Although defense counsel has no evidence provided by the prosecution that Mr. Daybell's sister-in-law has information or evidence in this case, there is information regarding her connections through marriage to law enforcement. Although I have no direct information that anyone in law enforcement spoke to Mr. Daybell's sister-in-law, I have great concern that local law enforcement in this case are speaking or have spoken to people in the community about the facts of this case. The continued untruths that somehow Mr. Daybell is involved in some type of cult activity continues to be presented to the local community. Although there is significant reference to LDS scriptures and religion, the suggestion of cult activities is continually being advanced without any merit. The survey presented to the court, performed by defense counsel and provided as an exhibit, supports the assertion that a fair trial cannot be had in the 7th Judicial District. It shows that not only was the person conducting the survey presented with threats from Bonneville, Madison, and Fremont counties, that the vast majority of people interviewed stated that they have already made up their mind regarding the guilt of the defendants. Further, that the vast majority would not change their mind. East Idaho News, who has a dominant and expansive readership within all of the 7th Judicial District, has on almost a daily basis reported on information regarding this case. It has published interviews with material witnesses to the case, published numerous pictures of the location where the bodies of the children were discovered, photos of the courthouses laced with ribbons and pictures. I have also submitted numerous photos of businesses and places within the 7th Judicial District community expressing opinion on this case. Considering the pretrial publicity and the strong feelings in the community about the case, the court should take appropriate steps to protect Mr. Daybell's right to an impartial jury. In addition to moving the venue to a larger population base within the state, we would request the court juror questionnaire should ask if the panel member have been exposed to any pretrial publicity. After the nature of the case is explained to the panel in person, it should follow up on its written question to see if any other panel members now realize their exposure to pretrial publicity. All the panel members who have been so exposed should then be questioned. The local news agency, whose readership encompasses all of eastern Idaho, has made the ability to panel a jury in eastern Idaho impossible. The largest population in the state is in Boise, Nampa-Caldwell area in western Idaho. The hope of finding an impartial jury from a larger population is far more likely than in a very small number of eastern Idaho rural communities whose local media agency has an incredible following. Conclusion: Defendant Chad Daybell requested all information in regards to survey, articles, media coverage previously submitted to the court and the prosecution well in advance of submission of this memorandum be admitted in its entirety to support this motion to change venue. Further, the defendant, through his legal counsel, requests oral arguments on this motion that the venue should be changed. Further, that the court direct that the venue be changed to an area of the state in western Idaho where the largest population of our citizens reside. There we go. That's John Pryor arguing with the court that he wants to change a venue. Now, I agree. Right, I am all for fair trials because I don't want to go through a whole process of the trial and then to get overturned on appeal because of an issue like this. So I am all for them having a change of venue. But his reasoning I find a little questionable. I do agree that in the local area, certainly where they are right now, they probably can't find an impartial jury. Right, because most thinking people look at this case and it seems kind of obvious what happened, right? It's hard to be impartial and to think, well, maybe they didn't do it. I can't see how that's even possible. So I'm all for the change of venue. But he cites some really strange things. First of all, remember the letter that was sent by Chad Daybell's sister-in-law. Right, she's the women's stake president type thing in her area, and she sent a letter about the case at the direction of the church, apparently. So that's a problem, right? And it's very interesting that he's introducing that in this because that could be a bigger thing that we see coming in the trial. I do think that Pryor is going to drag certain church officials into this. Certainly the stake presidents, possible Bishop Gabe, people like that. We are going to hear from them, or at least Pryor is going to try and throw them into this mess at some point. He also talks about the ribbons and pictures and things being out and about in the world. Now, he refers to when they were decorating the courthouse. Right, and we saw that. We saw pictures of that. Nate Eaton from East Idaho News, who Pryor also cites, did have a lot of pictures, and I even showed them of the ribbons and pictures that were up in the courthouse lawn, right, before the preliminary hearing. So, yeah, okay, he's got a point there. Maybe that shouldn't have happened. I don't think that he is referring to the memorial at the property. But yes, there has been a huge outpouring of community support for the family and remembrance of JJ and Tylee. Of course there has. This is a tragic thing. That's going to happen. But yes, that could legally be part of a pretty solid request for change of venue. The other thing he brings up, which I found kind of jaw-dropping, was that he wants Tammy Daybell's autopsy report. Interesting. Tammy Daybell's death is not a part of the current charges in any way, shape, or form. All right, they could be later on, of course, but right now all we're dealing with is the destruction or concealment of the remains and the conspiracy to conceal the remains. That has nothing to do with Tammy. So for Pryor to be bringing that up, I think is very interesting. I think he might be trying to put a little pressure on Rob Wood, and he certainly might be showing us one or two of the cards in his hand of things he's going to be bringing up. So we'll keep an eye on that. So that's what we have here. This hearing, like I said, will be on January 6th, so we'll be able to stream it live. I'm pretty sure Judge Boyce has been live streaming everything from his own personal YouTube, or his YouTube from the court, so I will bring that to you live when it happens. Also on the 6th, Lori Vallow will be having a motion to dismiss hearing. There's all kinds of things. January 6th is going to be a big day, a lot of stuff to cover, so stay tuned till then. I do expect to hear a response from Rob Wood on this memorandum, possibly, but he doesn't have to. I don't think he has to respond to a memorandum in support of a motion already in place. But if he does, we'll cover that as well. Alright, so there you have it. You can read the entire document. It's in our Discord server. Justin Lum of Fox 10 News. Follow him on Facebook and Twitter. There are links in the description to all of his social media. He is always the first one to get all these documents out, so follow him. And you can pick up all the documents over there on his Facebook and Twitter if you want to have a copy for yourself as well. So, thank you for listening. I'll keep you posted on whatever happens next, and stay safe out there.